Well, it's not typical for founders to have employment agreements in startups. Usually that's something that comes a little bit later on in the process when investors come on board. It's not a bad discipline to start putting employment agreements in place, particularly for non-founder staff at an early stage. We definitely always need IP agreements with everyone, including founders. There may be some pre-incorporation intellectual property that you created before you form the company that needs to be brought into the company. And then as you go along, there's always going to be IP created in the company as you progress. And you should have at least agreements in place with your contractors and employees for protection of that intellectual property and to confirm its ownership by the company from day one. As far as the other terms that relate to employment, most of them can be satisfied by a fairly straightforward letter agreement. And here we're talking about things like, what are the compensation details, what are the vacation details, and things like that. You can also try to put some restraints in place with respect to competition and non-solicitation, but you have to be very careful about what you do there and speak to your legal counsel about that, because non-competition and non-solicitation provisions in contracts and employment contracts are very difficult to enforce. They have to be reasonable. They're very much influenced by the jurisdiction in which the employee is employed and so on. So that's kind of an area where you need to take some care if you're going to put anything in. The other area that's always obviously very good to have some kind of provision is on termination. What are the entitlements of an employee on their termination from the company? Is there a probation period? How many weeks of notice or severance are they entitled to, and so on. And employment contracts act to restrict some of that and protect the company. So it's obviously good to put them in place.